evening to all of you. This is yet another program on wills and nominations, and we are really very, very happy that Mr. Israni has agreed to conduct this. I am Devashish Basu, and I am a trustee of Moneylife Foundation, apart from being the editor-publisher of Moneylife magazine, and I'm delighted to introduce Mr. S.D. Israni today. Mr. Israni is an advocate and partner of S.D. Israni Law Chambers and has over 36 years of experience in the field of corporate, commercial, and securities laws. He has simply written the book on India's securities laws, which cover the Securities Exchange Board of India, copies of which he's very kindly donated to Moneylife Foundation. If you come to our library, you will see 2-3 volumes of his work, which is absolutely phenomenal, and everybody refers to that. Mr. Israni's professional achievements are formidable. He was a member of the Naresh Chandra Committee for Simplification of Company Law relating to private and small companies. He has been on SEBI's Committee on Disclosures, called the Maligam Committee, and the one on buyback of shares. Mr. Israni has been a member of Legal Affairs Committee of the Bombay Chamber of Commerce and Industry, Indian Merchants Chamber, and Indian Council of Arbitration. He is an active member of the Institute of Company Secretaries of India. He was on the Central Council for 4 terms and headed the Capital Markets Committee of ICSI. Interestingly, he is a director. He's trustee of the ICICI trusteeship company, under which comes Disha Counseling, which has partnered with Moneylife Foundation for counseling. Mr. Israni is not just an accomplished professional in the area of law and taxation. He is ever willing to share his knowledge, and he's written extensively for the Economic Times and also for the Financial Express, and we are very proud to say that he is now a columnist for Moneylife as well. Friends, ladies and gentlemen, please welcome Mr. S.D. Israni.
Good evening, friends. At the outset, let me thank Moneylife Foundation for giving me this opportunity to be here this evening before all of you. I'll try and share some thoughts on the subject. At one level, this can be a very vast subject, but then having regard to the constraint of time, I'm not going to get into the personal laws, nor this is a technical class, so I'm not going to get into the sections as well. What is important is to discuss few things about making of a will, various aspects of that, then of course the issues relating to nomination and transmission. Friends, according to me, making a will is not merely a legal exercise. It is much more than that. According to me, it is an emotional exercise as well. A lot of personal thinking and thoughts go into it, and it can create emotional issues in the family. Now, when I was thinking about this subject, I happened to pen a few words, and with your permission, I would just recite those, and those words happen to be in Hindi, so please bear with me, and I'm sure most of you should be able to follow. I've just given a title, Lahu Ka Rishta. Lahu Ka Rishta. गहरे संबंधी है आपस में पर कोई संबंध न रहा. गहरे संबंधी है आपस में पर कोई संबंध न रहा. लहू का रिश्ता है इनका, बस रिश्ता ही रह गया. लहू का रिश्ता है इनका, बस रिश्ता ही रह गया. लहू तो कब का यूं ही बह गया. लहू तो कब का यूं ही बह गया. जाते जाते यह भी कह गया. लहू तो कब का यूं ही बह गया. जाते जाते यह भी कह गया. रिश्ते खून से नहीं प्यार से सींचे जाते हैं. रिश्ते खून से नहीं प्यार से सींचे जाते हैं. शिव जिनमें दिल ही न हो वो इंसान नहीं बुत कहलाते हैं. वो इंसान नहीं बुत कहलाते हैं. Thank you. So the point is that it is all about relationships based on love, because underlying theme is trust, and then we find over a time When you lift the tea out of trust, you find only rust. And then the problem starts. Just in Hindi, they say the word Vishwas. And there is the vish, the poison, presence of poison in the word Vishwas. So the relations are such complicated thing. At one level they can be very simple. At another level they can be really complicated. So I thought I'll start my talk with this slide. At death, those heirs that seem the saddest, behind the mask may be the gladdest. This is what Art Burke at Once Upon a Time said, that a lot of hypocrisy goes on, and that comes out in the open when a person dies and his property is available for the legal heirs. Another one in that genre, there is no reason to be the richest man in the cemetery. You can't do any business from there. Now, of course, what this conveys is, or what I understand by that, why should always a person wait till the end and put everything in the will if a lot of things can be done during the lifetime itself? Whatever can be done during the lifetime, whatever can be transferred during the lifetime, one need not put everything in the will to be done after the death of the testator. For example, shares and securities. It is possible that if I intend, it is my property, let me be the first name. Second can be my son or daughter or whoever to whom the shares are supposed to go after my death, so that during my lifetime I am getting the dividend, and during my lifetime nobody can sell without my own signature. But after the death, whether there is will or not, these things automatically go to the joint holder without any other action, as we will see later on when we come to transmission, how those shares get transmitted. The point is that one need not keep on accumulating and holding. If by and by it is possible, of course there would be various factors, and each case will depend upon its own merit, and each individual has to decide for himself and herself. There cannot be any hard and fast rule which everyone has to follow. But the point is that during the journey, whatever is possible, having regard to the circumstances, then one should try to do, so that one need not be holding right till the end. This was another one I thought I should share with you all. We all live under the same sky, but we don't all have the same horizon. That is, we each one of us has a different thinking. We may be in the same country, in the same city, maybe in the same family, but still we have our own thinking. No two persons, no two brothers or sisters or family members would be same or even similar at times. So that is a natural fact of life. Now, why will is so important? And why are we here today to discuss about making of a will? How many of you would believe that there was a time when there was nothing like a will which was recognized in India? Just a couple of centuries back, there was no will, there was no provision for will. It's hardly little over 2 centuries old, the provision of will which is there. And as the word will itself indicates, and Moneylife Foundation normally mentions, where there is a will, there is a way. And I like to put it little differently, where there is a will, there is a way, but where there is no will, lawyers will make you pay. So try and avoid that, because if there is no will, then you will have greater wills from the lawyers. Now, is it necessary that for everything you should have a will? This is one of the questions always asked. Or is it only for the immovable property there should be a will? We'll come to it a little later. But just to tell you that merely making of the will by itself is not the end of the story. It's rather the beginning of the story. Before we proceed further, what is exactly meant by will? In general parlance, we may know, but what does the law say? Will is a legal declaration of the intention of the testator with respect to his property, which he desires to be carried into effect after his death. Remember, will is one document which has no effect unless so long the testator is alive, and it becomes automatically a legal document on the death of the testator. But it has certain characteristics which it has to fulfill. But before we go to that, I would like to familiarize you all, or many of you may be familiar with certain terminology or terms which are used in this context. After the will comes the codicil. Codicil means an instrument made in relation to a will. It is not an independent document. It is made in relation to will, explaining, altering, or adding to its dispositions, and shall be deemed to form part of the will. Which means, by itself, codicil is of no value. It is always in correlation to the will, and little later we will see how codicil is made and how otherwise it can be ignored by the courts. The next definition in the context is that of the testator. The person who makes his will in law is called a testator. And in contradiction to that, the person who doesn't make a will, when he dies, he is referred to as having died intestate. Any person who dies without executing, making a valid last will, is known as dying intestate. In such a case, the heirs would be governed by the Succession Act or personal law of the deceased. These acts give the order of succession. And that is one of the reasons why a will is necessary. It is necessary that it is your property, and you have to decide how that property should be utilized, in what manner, who should be entitled, to what extent, which organization you would like to donate, and so on. If a person dies without making a will, then even, for example, I may desire that so much money should have gone to a particular organization, which I never gave during my lifetime, because I never had that confidence or suffered from sense of insecurity or fear, don't know how long I will live, what will be the condition of my health, how many medical expenses will be there, and so on and so forth, and I don't make a will, then all those feelings remain with me, and there will be the relatives, depending who are my survivors, and as per the personal law, who are entitled, they can all make a claim. But certainly not the very causes which were dear to me can make a claim, because there is nothing in writing. And those causes don't find place in law. In law, it will be the relatives who will be there if a person dies intestate, who will be entitled. And who are those? They are the heirs. Heir means any person, male or female, who is entitled to succeed to the property of an intestate. So when a person dies without a will, then the law provides a long list of relatives. There is a first degree relative, there is a second degree relative, starting with the spouse, parents, mother, children, and further down the line other relatives. So if no will is there, then it opens the floodgates for a lot of litigation as well, depending of course upon the size of the estate which will be there. But if the will is there, as I said, that by itself is not the end. We'll see a little later how even when you have a will there could be issues. But for the moment, if a person dies intestate or without making a will, then all the relatives as per the respective personal laws, whether it's Hindu law or Mohammedan law, Indian Succession Act, different family groupings would be entitled to stake their claim. Now, so far as the persons who are entitled under the will, known as legatees or beneficiaries who inherit the estate, this is a term which you will find used everywhere. Then one of the more important terms which finds use is the executor. Executor means a person to whom the execution of last will of a deceased person is by the testator's appointment confided. Now, executor is the person who is going to carry out the wishes of the testator, the person who makes the will. His or her wishes after death will be carried out by the executor. Who should be the executor? It is purely individual decision. It is for the testator to decide. A person whom the testator has confidence, and a person who, although nobody can guarantee about age, but generally, preferably much younger than the testator, so that there is a reasonable chance, and God forbid if something happens to the executor during the lifetime, then yes, you have to make a provision for the executor, but that is a general thing which is there. Then executor acts as a legal representative for all purposes of the deceased person. For all practical purposes, the executor becomes the owner for the purpose of the third parties in the world. But he is not the owner. He may be exercising the rights. His capacity is of a representative and not the owner of the property, although he may appear to be so. And even in some cases, he may act so. But he is actually a trustee. His role is of a trustee. He has been appointed to discharge the duties which have been cast upon him by virtue of that will. And therefore, when an executor is appointed, he should be a person of such confidence that you are assured that there are very negligible chances of his turning other way around, and that he would be a fair person to carry out the wishes of the testator. And then, as representative, whether it is before the government agencies, before the courts of law or elsewhere, he has the authority by virtue of that will to represent on behalf of the estate. This is another term again you will find in this context. Administrator, a person appointed by competent authority to administer the estate of a deceased person when there is no executor. Now, for example, Mr. A dies and his will is there, executor was there, he is no more interested in pursuing or discharging his functions, by virtue of the will, maybe because he finds the job too onerous, or his health has given way, he is no more that young or healthy as he was, or he has other personal reasons, or to put it simply, he is no more interested in doing the donkey's work, and therefore he refuses to act as an executor. But what happens to the property? What happens to the will, which is there? Or even if it is not there, somebody has to administer. So you go to a court of competent jurisdiction and have an administrator appointed, and as the term itself indicates, somebody appointed to administer the estate of the person who might have died intestate, or where the executor refuses to discharge his duties, or executor himself is incapable, or he is himself no more. Now, this is the term estate given to the total property which a person leaves at the time of his death, which was owned by him, the sum of all the assets of a person less his liabilities becomes his estate. In short, all properties, bank accounts, investments, insurance and collectibles less the liabilities of a person are collectively called a person's estate. And therefore, when there is an executor or an administrator who acts as a representative of the testator, it is his job to take due care of the estate. And whatever is required to be done, he has to do, and then whatever expenses are to be incurred, those are incurred from the estate. Whether he has to, when there is a large estate, like for example in Bombay, one of the largest estate was owned by F.E. Dinshaw, practically entire Malad and those areas. So there was a whole organization to be appointed by the executor, the managers, lawyers, because it was a vast property. So when there is a large estate, it may not be enough that there is an executor. Executor himself may need a team of persons to perform the job, to administer that estate. So it will always depend upon the facts and circumstances of each case. No two cases would be same, there would always be differences. And therefore, you realize the role of the executor in administering the estate. Now we come to the term which is another very popular term, probate. Probate means the copy of a will certified under the seal of a court of competent jurisdiction with a grant of administration to the estate of testator. Now many times this question is asked, is it necessary to probate? Or will is enough? Well, general answer would be, it will again depend on the facts. If there are no issues and you don't have any immovable property which has to be mutated or registered with the sub-registrar, then perhaps you may not need a probate. If you have only movable properties, you may not need a probate. If there is no challenge to a will, then you may not need a probate. But if you have immovable property, if you have property which needs registration, if you have challenge to the will, if any of your relatives challenge the authenticity or validity, genuineness of the will, then of course there is no choice but to go to a court of competent jurisdiction. Probate is basically stamp given by the court of law upholding the validity of that will presented before that court. And we will see a little later how court is expected to perform that role. Now, after having explained to you the various important terms, we come to the actual task of making of the will. Now, what does it, that is, goes into the making of the will? But before that, let me again share a quote with you, which has a deeper meaning, as you will see. If you wish to travel far and fast, travel light, take off all your envies, jealousies, unforgiveness, selfishness, and fears. Because as human beings, we are subjected to all these qualities. When will is being made, let us be cool and calm. Not that my that elder son who acted against my wishes and married out of caste, so I will not give him anything. Or my daughter who ran away and love marriage, so she also is out. So instead, keep yourself calm, cool, and then make a will. So that's why I felt like sharing this with all of you, just to derive home the point that as it is said that nobody has succeeded in carrying anything, so each one will be leaving everything. So why not do that with a calm mind? Whomsoever you want to give is your property, but do it with a peaceful and patient mind. Now, what are the characteristics or requirements of a will? How do you know a particular document is a will or not a will? Is it not enough that you mention will and becomes a will? Not necessarily so. Just writing a will does not necessarily become a will. So we will see what are those characteristics or requirements for a document to be called a will. And will here in the legal sense, in general one may have any document claiming it to be a will, but when we are talking of a will, we are talking of a will which can be upheld as will in a court of law. First of all, it is a legal declaration. It has to be a legal declaration by the testator. He is declaring about his own property. And remember, it has to be his own property about which he has to make a declaration. He is going to make a declaration about himself, declaration about his family, which facts are there, that who am I, what is my age, I am in healthy condition, what is my family, my spouse is alive, not alive, how many children I have, how many marriages I had, first marriage, second marriage, all these facts, so that there will be less complications later on for your survivors for whom you are trying to plan out the things. So detailed legal declaration will be required. Although, remember, in law there is nothing of that sort mentioned what you have to mention. That will come to a little later when we talk of the form or contents of the will. But a good document is one which is simple, at the same time comprehensive enough, which will solve issues and not raise problems. And therefore, drafting of a good will is very important. Now, the most important feature of a will is disposition of property. If there is no property, there is no need for a will. There is nothing to be willed about if there is no property. So obviously, now when we talk of property, what do we mean? Yes, obviously we are talking of immovable property, houses, land, etc. But that is not the only property that is there. There could be so many movables. Till few years back, mainly we would talk in terms of movable property, immovable property. But today it is much more. There are the intangibles, IPRs, or the intellectual property rights. Copyright. There is an author who writes a book, his copyright is there. What happens to the copyright after death? Who will get that? There are the paintings lying at home. Who will be entitled to the paintings? Like few days back or few weeks back, you might have heard the fight going on in a particular family about paintings, that these costly paintings are bogus paintings, etc. Because today paintings have value, but not every member in the family will have that kind of a feeling for a painting. For some it will be a space wasting, money wasting tactic, so he would like to sell off at the first available opportunity for whatever he can get. For other, it's a matter of love. So who is your child or relative who will take care? So you provide for that. You are a lover of dogs. You may have half a dozen dogs. But as they say, dogs may go to dogs after death. Unless you provide, that who is that relative who will take care? Whether it will be my son, daughter, my friend. Because remember, in a will, you have no limitation. It is your document. It's like you are creating a constitution which your executor has to follow later on. And you are free to create the constitution and provide for the property, but only that property which belongs to you. And if it is a joint property, only to the extent of your share in that property. You cannot, like for example, I am standing here just now. I cannot will away this hall because I have not only no ownership, but no rights at all. Just because standing here and talking does not give me any right. I have only a permission to come and stand and talk and go away. So the property which I am going to dispose through a will is only that much which actually belongs to me. And if it is ancestral or anything, then only to the extent of my right in the share of that property. Problems arise many times when people try to include more in the will and then giving rise to a dispute which then goes on from generation to generation, because once a dispute arises in a court of law, if you are fortunate, then it may be during the lifetime. Otherwise, if somebody wants to fight, then maybe the children or grandchildren may get the decision. So, it is not only the physical property which we are talking about, it is not just the normal movables, but the intangibles, as well as your own hobby or love for things which is there, and that itself has generated something which you want to be taken care afterwards. Maybe you will like that the dogs, as I was referring to, the pets, you would like the particular society should take care of them, and you may like to leave certain amount for the society. So only if you provide specifically in the will, your relatives may do it, may not do it, but if you are provided for, then the executor is duty bound, because he has to follow. So try to make it as comprehensive as possible. Now, a natural question which arises, that I am making the will today, but I may survive 10 years, 20 years, 30 years, I don't know. The same property which is there today may not remain at the time of my death. Nothing to worry. Because after all, will is made, there are two parts. One is where you give the property description. Then there is always a residuary clause. A clause which says, all such property which I may own at the time of my death, and which is not mentioned in this, or I may acquire after making of this will. So properties could be acquired, properties could be sold. So what is willed today may not be exactly the same what is available at the time of the death of the testator. Perfectly possible and normal. But then will is all about what the testator owns at the time of his or her death. That is a material point, and not only what he owned. What he owned at the time of making the will, yes, he is restricted to that. But when he acquires, then automatically there has to be a residuary clause, which is going to, that's why many times there are defective wills or inadequate wills, incomplete wills, which raise, then what happens in such a case? Then in that case, suppose I make my will today and today's properties are included and I have mentioned what to do with those properties, but I survive for another 10 years, 20 years and I have acquired certain other properties. I don't make a new will and I have not mentioned anything about the properties I would be acquiring in future during my lifetime, what to do though with those properties. Then in the same will, I will be a testator so far as the properties where I have clearly mentioned what is to be done, and I am supposed to be dying intestate about the properties of which I have not mentioned what is to be done, because it is as good as there is no will vis-a-vis those properties. So if I acquire properties and the will is silent, if the will says that any other property not mentioned herein which I may acquire subsequently or which I may own at the time of my death shall be utilized in a following manner, then it's fine. Otherwise, that much property will be treated as intestate, and then you have to go to a court of law and get instructions, have an administrator. It could be the same executor of the will whom the court may agree to appoint administrator if there are no objections from other relatives or anything, but it's for the court to decide. The point is, to that extent, so it is possible that one can be a testator, have a will, and also in portion of the will, it may be for portion of the property, he could be deemed to have died or she as intestate. But the point which you should remember, that try to make it as comprehensive as possible. Now, one of the very important characteristics of a will, that it is a will, it really becomes a legal document, comes into effect only on the death of the testator. No death, it is not a will. It is only intended. It has legal efficacy only if the person dies. If the person keeps on living, it is only an intention, because he has every right to change the will, she has every right to change the will. And therefore, unlike other documents like sale deed, transfer deed, they are inter vivos between two living persons or between two legal persons. But will is one made by individual which becomes a legal document only on the death of the testator. This is another very important characteristic of document what we call will. If it cannot be revoked during the lifetime of the testator, it is not a will. Will has to be revocable. Whether it is revoked or not is totally the option. But the power, the right should be available. It is for me to decide whether I want to make a fresh will every day, every week, every month, or not to make at all. But if I make, I should have power. If there is no power, then it could be a sale deed. It could be a transfer deed. It could be anything, but it is certainly not a will. So therefore, revocability is very important. Now, what should be a language of will? This is one of the very common questions which invariably so many persons ask. In what language do you write a will? The clue is in the word itself, will. It is your will, which you can express in the language in which you are comfortable with. There is no reason that you have to write will only in English or in Hindi or Marathi or Gujarati. You have to express yourself, but the expression should be clear, unmistakable, unambiguous, as I said, as far as possible, simple. So any language you can choose, but there should be clarity and consistency. Now this is one of the other important issue which invariably gets raised. What is the form or the format of a will? is there any designated form? Is there a particular manner in which the will should be drafted? Fortunately, the law is very clear on this issue. The form is the one which you resort to. In other words, there is no form. You can express your will in any manner you like to have. But it always helps if you draft the will in a particular order by starting by saying what is your full name, your parents' name or husband's name, depending on the facts of the case, where you are currently staying, what is the condition of your health. Because remember, when will is challenged, one of the grounds invariably, particularly in old age, is the health of the testator. And invariably that he or she was not in a state, or the mental condition was such that he or she could not have done what is purported to or claimed by the other side, so it is not a genuine will. Then you, after mentioning the details, it is very important to talk about the issues, to talk about the marriage. Now just last month only one will which I made, a bachelor of around 50, he wanted to make a will so that he wanted that whatever he has should entirely go for good causes like education of girl child and other social causes. He is a bachelor, he has no brothers, no sisters, cousins are there, whom he has made executor to take care of the property. And particularly, I asked him why you are keen to make a will. He said, because I want the money to be utilized for the causes which are dear to me. And those are basically relating to education and other social causes for which the money can be utilized. So therefore, it is very important to mention, that's why I told him that in your will, although you are a bachelor, everything, mention in so many words that you are never married, you have never adopted a child, because suddenly when property is there, a lot of adopted children also come over. So, the spouse would wonder what is happening if there is one. And that's very important to say. Like one of the examples I used to give in one of the earlier talks, a distant relative of mine, now in his 80s, it took him almost 4 years finally to sign the will. Sucheta of course knows very well, because from the first workshop I had been talking of that. Every few months he used to tell me to change something in the will. And first 2 years the will never got finalized, it took 2 years to finalize. After finalizing, he just kept with himself, but he would not sign. Then I sensed he had a fear that if he will sign, he will die. Now that's why it is an emotional decision for many. An issueless couple, now in his 80s. Finally, one day another relative asked him, what about the will which Israni had made for you? He said, Israni has told me not to sign. And then I got a call, said, why, well, you have told him not to sign. And then I realized that he has that fear. Then I told him, peacefully you sign. He said, you never told me to sign, that's why I did not sign. So eventually, without exaggeration, it took 4 years for the gentleman to finally sign the will. And now it has been more than 6 months, he is still hale and hearty. Now here the issue was, this is a couple have no issues. And they want all their property, the apartment where they are staying, whatever huge amount they are having in accounts, to go to their respective, they have their respective religious gurus, to those institutions, all their gurus of property should go. And see the interesting thing, property of course generates a lot of interesting things. Here, one of the religious guru came to know that this property is going to be put for their benefit in the will, it will be there. He was very keen to know when the will be executed. A very leading, well-known religious group, I don't want to name it because that is not the point, but the point is that it was very centrally located, right very close to Linking Road, a good 3-room apartment, so anybody would like to live there, even religious people. So, there I mentioned the will very clearly that they have never adopted any children, because as we have seen over the years, sometimes what happens, such couples, they take some relatives' children who are not well off, help them come up, and for all practical purposes they say, you are my son, my daughter, I will spend your marriage expenses, I will get you educated, so you are like my... And later on, issues arise when that child comes forward and says, Dad adopted me. Only technically the surname was not changed, but otherwise I am the issue. Now if these all are clarified and mentioned that no adoption was done, etc., etc., then these issues, when the matter goes to court of law, what does the court do? There are Supreme Court judgments which very clearly say that court has to sit itself in a judgment as if it is a testator, and what testator would have wanted to do in those given circumstances, court should try to visualize as far as possible. And there, the clarity in the will come to the help of the court and eventually fulfill whatever the wish of the testator. And that is why, now one of the interesting cases I was reading, the names also were interesting. One was Bhagatram, another Chagatram, sons of Mastram. And these are not my creations, Supreme Court judgment. Where the court says, perhaps they are the children of his current wife, or not necessarily, but we are not concerned with that. Court makes that observation. Making observation then says it's not material, so leave it at that. So if there are, and earlier, of course, it used to be quite common in many families having second marriage, third marriage, due to death of the first wife or otherwise. There will be children from the first marriage, second marriage. All these have to be provided for. Then in some cases what happens, that during the lifetime of the testator, there is already a provision made. And the testator believes that he has nothing more to give to this particular son or that particular son or daughter, whatever. Then it is always better to mention in so many words in the will that so far as my this eldest son is concerned, to him I have already given, etc., etc., during lifetime, so I have nothing more to give to him, and he has no rights so far as the remaining property is concerned. So that tomorrow he raises the issue, then the document itself is saying so, the court is going to follow that. But if it is silent and others raise the issue, no, my father had already given his share, there is not much of evidence, then there are issues. So that's why I say, as comprehensive, simple yes, but as comprehensive as possible, it should be there. And as there is a freedom, there is no format, you can put it in any manner you wish. This is another issue which always comes up, attestation. How important or how necessary is it to have the will attested? And what do we exactly mean by attestation? In simple terms, it means it has to be signed by someone else witnessing the signature of the testator. And two persons are required to sign the will. So suppose it is my will, I am the testator, my signature, there will be two witnesses, maybe one can be Suchita, another Devashish, and they will be the attesters who attested my will. What they attest is not the will itself, that is the contents, they are not concerned. To whom the property goes, it is not their lookout. They may not even know. But yes, what they know is that this is Israni's signature. He has signed in my presence and I have signed in his presence, so that the signature is attested. That is the only purpose, to ensure that tomorrow if it is claimed that this is not his signature, then perhaps there could be the attester who could give an affidavit or be called as a witness by court of law to confirm at least if an issue arises. Now, here normal practice is to have one attester as a doctor, another as a lawyer. Generally it is believed, although it is not required, let me be very clear, nowhere in law or in practice by court required, but in practical way it is done, although several ways are seen where instead of doctor attesting the testator, they take a certificate of the doctor about the condition of the health of the testator, annex that as a part of the will. So that when that issue about health is raised, the certificate itself is annexed. So that on the day on which the will was made, the testator was in good condition. But the idea is the condition of law will be met if two persons who are of the age, which means above 18 and above, in the age of signing a contract, of sound mind, and they themselves should not have any other issues which could detract from their capacity to sign. Then the next one is, this again a question which many times is raised, what is the amount of stamp paper required? How much stamp duty has to be paid? Fortunately, some things are still free and making will is still free. So there is no stamp duty levied by the government, but sure, as they say, death and taxes are the only two things which are certain. So one day, one fine morning, government may feel that they need still more money for all their VIP security, then perhaps they may start levying duty on our wills also. But as on date, you don't have to worry, just plain paper you take and make the will. This is another issue which again raises question, is it necessary to register the will? What happens if you don't register? Or for that matter, what happens when you register? Well, let me first tell you, there is no need at all to register the will. If you don't register, in no way the will, unregistered will, is inferior to any other registered will. Registered will only proves that on that particular day, this particular document purported to be a will was registered and that person was alive on that day. That's it. But that does not mean, because there is an impression in mind of certain persons who believe that once you register the will, then it cannot be challenged because it's registered on that day, so it's a genuine will. No. Challenging a will in a court of law is totally independent thing, irrespective of whether the will is registered or not registered. If it is challenged, then one who purports that this is a genuine will, he or she has to prove in a court of law, even though it may be registered. So genuineness of will has nothing to do with registration, and registration by itself does not afford you total protection, although it may raise prima facie that yes, on that day it also, it may indicate one thing, that this document came into existence at least on that day or before that day when it was registered. Whereas an unregistered, it could be that it came into existence yesterday when the person was dying and the will was made, or it was even created actually afterwards, although predated kind of thing. So here, there could be there. But whether that is the will, the last will, because ultimately remember the operating word is the last will and testament. Yesterday I made my will, that is yesterday's. If I make today, yesterday's will is zero. It has no value. That you have to remember. So any number of wills you make, the last will which you make, or which turns out to be the last will, that is what will matter, and not the earliest or the early wills. Friends, with this I come to the conclusion so far as will is concerned. I thought, let me close with this slide. Remember, what you possess in the world will be found at the day of your death to belong to others, but what you are will be yours forever. Now quickly, because I'm just having a look at my watch also, time is running out, I'll quickly rush through some of the slides on transmission and nomination, and then we can go for question answers. Now, transmission is a legal process by which the ownership in the shares get transmitted. It could be on devolution by death, succession, inheritance, bankruptcy, marriage. So it is a legal process of transfer, because transfer normally means interviews between two living persons or two legal persons. Transmission is by operation of law. Nomination of shares, this I want to deal it little in detail, it's very important. Under the Companies Act, there is a specific provision, section 109A, which permits every shareholder, security holder, let me say today, that's because debentures are also included. Every security holder can nominate anybody. If you are a joint holder, then jointly you have to nominate. You are a single owner, singly you will nominate. Now, till 2 years back, prior to 2010, nomination was understood as a very simple affair. Whether, I'll just run to another slide from where I'll take it. Nomination, whether under the Companies Act, Banking Act, Insurance Act, Maharashtra Cooperative Housing Societies Act, etc., was taken very simply that nominator is a person who nominates and nominee is a person who is nominated to hold the property in trust for the real owners. Now sometimes it could be the nominee themselves, could be the real owners, that is not the point. But where he is not or she is not the owner, there may be other claimants, he may be a joint owner. Real issue arose in the context of Companies Act, where under 109A, nomination is permitted to be made, but the definition of nomination has been tweaked, which was never bothered by anybody because the issue never arose. And whatever issue arose, this particular case came up before the Bombay High Court. 20th April 2010, in a way you can say a landmark so far as this particular issue is concerned. Justice Roshan Dalvi of Bombay High Court gave the landmark judgment that nominee in the context of shares and debentures becomes the owner of the shares and debentures. He is superior to the legal heir. Here, Harsha Nitin Kokate, she was the widow of Nitin Kokate, but the shareholder, that is her husband, had filed a nomination in favor of his nephew. And the court held that this nomination is superior to even the right of a legal heir. And why that happened? I want you to take you through those so that you will have an idea. Now in one subsection 1, last line, just to the second last line, the company, shares or debentures of the company shall vest in the event of his death. Now the more important is A person to whom all the rights in the shares or debentures of the company shall vest. A person to whom all the rights, and that is where the court has taken clue from, that unlike a bank account, unlike an insurance company, unlike corporate housing society, in case of a company, when you give a nomination to the depository, then and single nomination for all your shares in the single depository account, nominee will get all the rights of the owner, all the rights in the shares. And the court said all the rights include right of disposal also, because that person, that nominee, for all practical purposes is the owner. Let me tell you, that was not the intention originally when government was asked to make a provision for nomination. It was akin to insurance and banking, that the company should not be dragged by the parties fighting for their right in the property. Let it be amongst themselves. Company's duty should be discharged the moment it has recognized a nominee. By virtue of this judgment, and judgment is in the context of the provision of 109A, where the powers are given, the vast powers, today, as on date, it stands to that, because the words, if you read in the last, to the exclusion of all other persons, that is where the issue comes. Entitled to all the rights to the exclusion of all other, unless the nomination is varied or cancelled in the prescribed manner. That is the procedural part. It is taken for granted we are talking of a valid nomination. Then exclusive powers, and law itself says in so many words, to the exclusion of all others. So if any of you are given nomination, please remember that this is a consequence, but like will, you can keep on changing. Nomination also, you have the power to keep on changing. All it requires is, if it is a joint holding, the joint holders have to sign the new nomination. Otherwise, single holder, then single nomination. Then so far as transmission is concerned, that is basically, as I told you, the legal process of transfer, and there is a provision 109B which I need not go through, and the issues arising during question answer we can take up. With this, friends, I come to my last couple of quotes before I sit. I will share with you, and sorry, that has got mixed up, so I will not be able to show you. But let me thank Moneylife Foundation for giving me this opportunity to share my thoughts with you, and to all of you for patient hearing. Thank you.